This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about a bad faith setup that failed because plaintiffs and their counsel's bad faith defeated the suit against the insurer. It is evidence that no good deed goes unpunished when plaintiffs abuse the tort of bad faith. Julio, Palma, and Miriam Cortez, the plaintiffs, appealed an order granting summary judgment in a bad faith insurance case against Mercury Insurance Company. Mercury insured Frank McKenzie, who killed plaintiff's son in a car crash. Plaintiffs obtained a $3 million judgment in a wrongful death action against McKenzie. McKenzie then assigned plaintiffs his rights against Mercury, and plaintiffs brought the present action against Mercury on the basis that it failed to accept their reasonable offer to settle their wrongful death claims. The trial court granted Mercury's motion for summary judgment after determining that plaintiffs never offered to settle the claims. In Julio, Palma et al. Versus Mercury, a August 23, 2022 decision of the California Court of Appeals, the Court of Appeals refused to buy plaintiffs' claims of bad faith. In September of 2012, Frank McKenzie was driving a vehicle that struck and killed Oscar Palma, who was riding a moped. At the time, McKenzie was insured under a Mercury insurance policy with bodily injury liability limits of $15,000 and property damage limits of $10,000, the minimum required by the state. On October 15, 2012, Attorney Paul Zuckerman sent Mercury a settlement letter that identified Oscar Palma deceased, estate of Oscar Palma, as, quote, our clients, and stated that, quote, Oscar Palma, estate of Oscar Palma, demands that Mercury Insurance tender full policy limits to Oscar Palma, the deceased, and the estate of Oscar Palma to resolve their claim. The letter stated the offer was to remain open for 14 days until October 29, 2012. Mercury retained attorney Jeffrey Lim and instructed him to accept the offer. On October 19, 2012, Lim faxed the carpenter's firm a letter stating Mercury is tendering to the estate and all heirs of Oscar Palma Mr. McKenzie's $15,000 policy limits, in order to confirm that all heirs are included in the release for the policy limits. Please have the heirs complete and sign the attached affidavit of heirs. The carpenter firm, the plaintiff's lawyer, did not respond to the letter. On October 24, 2012, Lim told Mercury that McKenzie agreed to a settlement. The same day, Lim wrote a letter to the carpenter firm accepting the offer to resolve the death claim of Oscar Palma. Lim enclosed a check for $15,000 and represented that aside from the Mercury policy, there were no other policies in existence for the loss. Lim, however, inadvertently failed to attach McKenzie's declaration to the letter. Lim included with the letter his office's standard release of claims form, which required the release of all bodily injury and personal injuries and property damage claims and wrongful death claims. Lim told the carpenter firm, if you have any changes to my release, please let me know prior to October 29, 2012. The carpenter firm did not respond to Lim's letter or request any changes to the release. Between March and July of 2013, Mercury sent the carpenter firm 6 letters reiterating its offer of the $15,000 bodily injury policy limits. Lim responded by sending the carpenter firm a copy of McKenzie's declaration. He represented that the declaration had been received, but was inadvertently left out of my October 24, 2012 letter to the carpenter firm. Mercury sent the carpenter firm a separate response, stating its position that it timely offered its $15,000 policy limits to your clients to settle the claims against Mr. McKenzie. Regardless, on August 28, 2013, the carpenter firm filed a lawsuit against McKenzie on behalf of the plaintiffs, Ana Guzman Palma and the estate of Oscar F. Palma, a deceased individual. The complaint asserted causes of action for negligence, survival action, and wrongful death. Following a jury trial, the court entered judgment against McKenzie and in favor of the plaintiffs for $3 million on their wrongful death claims. Mercury paid plaintiffs its $15,000 policy bodily injury limits and was done with its obligation, although it had to defend Mr. McKenzie throughout the jury trial. Plaintiffs then filed a bad faith action against Mercury by obtaining an assignment from Mr. McKenzie in exchange for a covenant not to execute the $3 million judgment against his personal assets. Mercury moved for summary judgment and submitted evidence establishing the facts summarized earlier. The trial court granted Mercury's motion for summary judgment after determining that the carpenter's firm's letter offered only to settle a survival action on behalf of the estate and not a wrongful death action. Plaintiffs contended the trial court erred in granting Mercury's motion for summary judgment because there are disputed issues of fact concerning whether Mercury unreasonably failed to accept the settlement offer. California courts, according to the Court of Appeal, have derived an implied duty on the part of an insurer to accept reasonable settlement demands on such claims within the policy limits. An insured's claim for bad faith based on an alleged wrongful refusal to settle first requires proof that the third party made a reasonable offer to settle the claims against the insured for an amount within the policy limits. The plaintiffs must also prove the insurer failed or refused to discharge contractual responsibilities prompted not by an honest mistake, bad judgment, or negligence, but rather by a conscious and deliberate act which unfairly frustrated the agreed common purposes and disappoints the reasonable expectations of the other party, thereby depriving that party of the benefits of the agreement. In evaluating whether an insurer acted in bad faith, the critical issue is the reasonableness of the insurer's conduct under the facts of the particular case. To hold an insurer liable for bad faith in failing to settle a third-party claim, the evidence must establish that the failure to settle was unreasonable. The carpenter firm's October 15, 2012 letter cannot reasonably be interpreted as an offer to settle plaintiffs' wrongful death claims. A wrongful death claim is a statutory cause of action that allows a decedent's heirs to recover compensation for the economic loss and deprivation of consortium they personally suffered as a result of decedent's death. Wrongful death claims belong to the heirs, not the decedent or the decedent's estate. The carpenter firm's letter, however, does not mention plaintiffs or Palma's heirs, let alone identify them as the offerors. It is clear to the court that the carpenter's firm's letter offered to settle the estate's survival claim and not plaintiff's wrongful death claims. Because Mercury's undisputed evidence showed plaintiffs did not offer to settle the wrongful death claims, they cannot state a cause of action for bad faith refusal to settle those claims. Even if the carpenter's letter had offered to settle the plaintiff's claims, Mercury would be entitled to summary judgment because no reasonable trier of fact could conclude it acted in bad faith. The undisputed evidence shows Mercury directed Lim to accept the carpenter firm's settlement offer under the terms set out in its October 15, 2012 letter. The only reasonable conclusion for this evidence is that Mercury would have settled the claims under plaintiff's terms, but for Lim's negligence in failing to deliver McKenzie's declaration. Mere negligence, however, is insufficient to support a claim for bad faith refusal to settle. There was no evidence showing Mercury refused to remove the property damage language from the release or otherwise required it as a condition of settlement. To the contrary, the undisputed evidence shows Mercury separately attempted to resolve any property damage claims in November of 2012 before the carpenter firm informed it there was no settlement related to the bodily injury policy limits. Mercury made substantial efforts to accept the carpenter firm's offer. Among other things, it informed McKenzie of the offer, obtained his consent to accept it, tendered its full bodily injury policy limits, made substantial efforts to obtain and deliver the requested information and documents, and expressed a willingness to modify the release of claims form. Plaintiffs pursued a legal action against McKenzie, knowing it would hurt his credit and subject him and his family to extremely distressing and embarrassing post-judgment collection proceedings, not to mention going through a trial on its merits before a jury and having a verdict imposed against him of $3 million. The court concluded that if anyone acted in bad faith, it was the plaintiffs and their lawyers. In my opinion, the Court of Appeal established an attempt to wrongfully take advantage of the tort of bad faith by the plaintiffs acting in bad faith to an insurer who reasonably attempted to resolve a dispute against its insured by immediately accepting the offer of settlement, only to find plaintiff's counsel refused to accept the payment and bring silly arguments like requiring payment of a $10,000 property damage limit for a moped worth only about $1,000. This was an incompetent attempt at bad faith setup, where the court concluded that the plaintiffs and their lawyers acted in bad faith, not the insurer. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the link zelma.com/blog. You can subscribe to the blog and receive notice of every blog posting, which goes out almost every working day, 5 days a week. You can also subscribe to my videos on rumble.com or youtube.com, and I'd appreciate it if you click on the like button or the Rumble button when you do, and also consider subscribing to my locals community and my Substack publications. Thank you for your attention.